Hey everyone, welcome to another edition of the Daily Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every Friday, Alex Ooley of the Ooley Law Offices in Indiana. Alex, when we were talking earlier this week, the topic for today, of course, we all know the Second Amendment to the United States Constitution. And what most people realize, but maybe don't, most states have a right to keep and bear arms in their state constitution somewhere. Usually it's not the Second Amendment to the state constitution, but somewhere written into the state constitution is a right to keep and bear arms in most states, but not all states. Where does that, is it more important for us to have a federal or a state right to keep and bear arms? And is the state one superfluous?
Yeah, so that's exactly right. In fact, well over 40 states have their own corollary or parallel to the Second Amendment as a protection for the right to keep and bear arms. And unlike the Second Amendment, which is an amendment to the federal Constitution, most state provisions for the right to keep and bear arms are directly in their Constitution. But just like you pointed out, you know, when we think of the right to keep and bear arms, this applies to most Americans, including attorneys. We think of the Second Amendment and don't give much thought to state constitutional protections that might be available or that might protect that right. But that doesn't mean that they're not important. And in fact, they may be just as important, if not more important, than the Second Amendment. I'm not trying to diminish the importance of the Second Amendment because it's certainly very important. But I'm just trying to point out that state constitutions are often overlooked and can be a protection when the Second Amendment may not. And in fact, what a lot of people don't realize is that the Second Amendment didn't even apply to the states initially. The Second Amendment was only meant to restrict federal government action, not state government action. So many states early on adopted their own provisions as a protection of their citizens' rights to keep and bear arms. In fact, I think four states adopted their own protection of the right to keep and bear arms before the Second Amendment was even enacted or adopted. So there's a long history of state protections for the right to keep and bear arms.
If I'm remembering right, it's only been in the last 15 years or so that the Supreme Court made the Second Amendment to the U.S. Constitution apply to the states. Is that right? Yeah,
so like I said, the Bill of Rights, including the Second Amendment, only applied to the federal government as a restraint on the federal government initially. And it wasn't until the late 1800s, after the Civil War, that the Supreme Court started to apply the Bill of Rights to restrain the states through a process of what's called selective incorporation. And you're exactly right. The Second Amendment wasn't incorporated to apply to the states until 2010, when the Supreme Court decided the McDonald versus the City of Chicago. And in that case, on the heels of the Heller case, the Supreme Court decided that not only was the Second Amendment a guarantee of the right to keep and bear, the individual right to keep and bear arms, but it was a right that not only applied to the federal government, but also served to restrain state government from infringing on that right.
Okay.
Another thing that's important to remember that a lot of people don't realize is that the Bill of Rights, including the Second Amendment, serves as a bare minimum. Okay, it's the floor of the rights that are protected by the Constitution. States can provide more protection than the Second Amendment. Okay, so many state provisions and many state courts have interpreted their constitutional provisions to be more restrictive of government on your right to keep and bear arms. So in many states, the right to keep and bear arms is stronger under state law than it would be under federal law. The Second Amendment serves only as a floor, not the maximum amount of protection that you could get. So I think that's. Go ahead.
one example I can think of is, and it struck me, Pennsylvania specifically in their wording of their right to keep and bear arms protection in their state constitution, it almost exactly mirrors the Second Amendment, except for "shall not be infringed" is changed to "shall not be questioned."
Yeah.
So,
yeah, it's interesting when you read through the various state constitutional protections of the right to keep and bear arms, how they vary in different ways. Some states have simply adopted the Second Amendment verbatim, but they've enshrined it in their own constitution. Others have adopted their own version that's very different than the Second Amendment. And in some ways, I like some state constitutional provisions better because they're more clear, at least in modern language. They're more clear to us. It may not have been more clear at the time of the founding, but I think in modern language and parlance, it's clearer for most people.
If I'm remembering right, and I'm pulling this off the top of a recently scrambled brain, so I may be totally wrong here, but I'm going back several years in Louisiana, and they are one that I do not believe had a right to keep and bear arms protection in their state constitution. And if I'm remembering right, about 10 years ago, they put one in, and they not only put that in, but in the Constitution, alongside it, they put "this shall be given strict scrutiny," so the courts really had their hands tied.
Mm-hmm. Yeah, some states have adopted a level of scrutiny that they think should be applied to those sorts of cases. But I think you're right. In Louisiana, they actually included it in the constitutional provision, which sort of bypasses a court decision about what should be applied. So that was an interesting thing to include. I think maybe they learned from mistakes in the past. So that's a cool thing that they did. But still, we've talked about the advantage of states being able to provide more protection than the Second Amendment. But they said they can't provide less than the Second Amendment because the Second Amendment is the bare minimum. But why else are state constitutional provisions for the Second Amendment, for the right to keep and bear arms, important? Well, I think, Paul, as you and I have seen, and what many people have seen, especially over the last more than a year now with the pandemic, is that we've seen various state level responses in that regard, not with respect to guns, but with respect to lots of other rights, like the right to the free exercise of religion. So
the right to peaceably assemble.
The right to peaceably assemble. How various states have treated those rights differently. And I think that sort of highlights the importance of the federalist system that we have, where states can adopt policies that are closer to the viewpoints of their citizens, and people can move among the states to places that are more favorable to their viewpoints than they can from country to country. So I think if people in New York don't want freedom, they are free to implement policies that only provide the bare minimum of protection under the federal Constitution. But if other states want to provide more protections, then of course they can. So I think that the pandemic has highlighted that in lots of ways. But that also applies for gun rights, not just for these other rights that have been enumerated. The other thing is that if your rights are infringed and you're trying to seek redress for a federal right, an infringement of a federal right, or a right that's enshrined in the federal Constitution, it's very difficult to vindicate your rights in federal court. It's very expensive, very time consuming, and often it takes weeks or months or even years to vindicate those rights. And state court is not cheap or inexpensive or quick, but it's generally less expensive, quicker, and easier to access than federal courts. So if you have those rights enshrined in your state constitution, you can vindicate those rights through state courts rather than federal courts. And that's also been demonstrated over the last year and a half when churches or individuals try to get courts to restrain their local government from it, basically restraining them from exercising their rights. State courts had been able to react more quickly than federal courts, and they're typically quicker and less expensive. So that's another reason why state rights are important.
So almost like buying a Porsche compared to buying a McLaren. You know, it's $100,000 compared to $250,000. It's expensive either way you go, but I've got a shot at the Porsche, no prayer at the McLaren.
Right.
I want to get this one in. It's too long to fit in all of it on the screen, but I'll go ahead and get what I can. I'll put what I can on the screen and read the rest. John Lutine, the Delaware State Constitution provision, Article 1, I believe it's Section 20. A person has a right to keep and bear arms for the defense of self, family, home, and state, and for hunting and recreational use. His commentary then is, which is useless when there is only one party rule and the majority of justices on the state Supreme Court do not follow the state constitution. Is a right to keep and bear arms provision in the state constitution only as good as the court system in that state?
Yeah, I think that's a good point. He raises an important issue. If the courts don't give that provision of the Constitution any respect, if they don't interpret it like the plain language of the Constitution seems to say, then it's difficult to vindicate your rights. But like I said earlier, the Second Amendment there is there as sort of a minimum. So if the courts in Delaware don't provide that right, the deference it deserves, the respect it deserves, the citizens of Delaware can still fall back on the Second Amendment as a minimum, a floor for their right to keep and bear arms, because you can still vindicate your rights in that respect.
Well, and as was alluded to earlier in our discussion, and John, love you, man, and you're a great commenter. Dude, we got all kinds of space in South Dakota. The economy's booming. Come on out, dude. And that's the ultimate. We live in a free country. If you cannot stand where you're living anymore, there are states that are free. South Dakota, Idaho, a lot of states in the center of the country that are open, and we respect our citizens' rights.
Yeah, as a matter of fact, I was reviewing a few of the state provisions protecting the right to keep and bear arms, and I thought South Dakota's was pretty good. I've got it in front of me here. It says, the right of the citizens to bear arms in defense of themselves and the state shall not be denied. I think that's pretty simple and a pretty clear statement of the right to keep and bear arms. And I suspect the courts, and I don't know, but I suspect the courts in South Dakota are more favorable to individual rights than the courts in Delaware, at least when it comes to the right to self-defense.
Not being an attorney, I can't speak to that. I don't have the experience, but I would say the chances are very, very good that you're right. Warsaw Patriot, the problem with our country is that people are using the same power of the law against us. And then he follows up with positive versus negative, negative versus positive. I'll say this, there are some people with very deep pockets, Bloomberg, who are willing to pay attorneys a lot of money to argue the other side.
Well, and that positive versus negative, negative versus positive, that could be in reference to a number of things, positive rights versus negative rights, but it also could be in reference to a positive statement of rights versus a negative statement of rights in the Constitution. So some states say that the right shall not be infringed. Others say that all persons have the right. So it's a positive application. I found one like that in particular. New Hampshire says that all persons have the right to keep and bear arms in defense of themselves, their families, their property, and the state. So there is no provision in there that says that right shouldn't be infringed or can't be infringed, but it does state at least a positive right. And then other states also include the negative provision that that right shall not be infringed. So I'm not sure if that's where the comment was going at, but that's
I don't know.
One interesting thing, just talking about different provisions in state constitutions, some states that you might think would have really strong provisions in their constitution, I was a little surprised are not so good. But the right to bear arms there is still respected. The constitutional provision is just not so great. I had Tennessee in mind here. That the citizens of the state have a right to keep and bear arms for their common defense. And here's the bad part that I don't like. But the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime.
Oh.
So, yeah. So with a view to prevent crime, I mean, that seems like an open-ended invitation to restrain the right to keep and bear arms if it prevents any crime.
And Tennessee just this summer got constitutional carry.
Right.
Through its legislature, so.
Right. Yeah, their Tennessee is generally very favorable to the right to self-defense and the right to keep and bear arms. But the constitutional provision it has some language in it that I don't like, that's for sure.
Some of the states that don't have a provision in the state constitution, I don't think would surprise anybody. California, I know, does not. I would suspect New York, New Jersey, Connecticut are some, and I would suspect certainly Hawaii does not, along with some of the other more intensive gun control states do not have that provision.
Mm-hmm. Yeah, but I think also kind of important to this discussion, Paul, is, I mean, at the time of the country's founding, the states were seen as the primary defense of individual rights. They were seen. It was sort of this system, this federalist system, where you wouldn't have a strong centralized government that could restrain you from the exercise of your rights, at least not without resistance from the states. So I think that's why I think this topic is important to talk about, because state constitutions are just as important, if not more important, than the federal Constitution. So I hope this discussion sort of maybe piques some people's curiosity and gets them looking into the issue a little more.
Absolutely. This is going to take us down a sidetrack here, but I want to get a couple more comments from Warsaw Patriot in. Here we go. Law can be manipulated and used on the populace, and we are nothing but puppets when it comes to indoctrination. And he follows it up with this. A prime example these days is any woman can make a false act claim of accused rape, and an innocent man who has done absolutely nothing wrong is wrongfully arrested. The woman lies in court. My understanding is in most cases, the woman is still committing a crime when she does that and can be punished. It almost never happens, but and I don't know that it ties into Second Amendment so much. So,
well, I think that comment, it maybe not directly related to the Second Amendment, but I think it points out or is related to the problem with red flag laws, right? Which we've talked about previously. That these proposed red flag laws and the Biden administration has made proposals about sort of a model red flag law that they think states should adopt. But of course, that's the problem with red flag laws, is that those laws can be abused, and your firearms can be taken from you without due process before they're taken. So your rights and your property are taken from you before you're given due process, and
Exactly.
that's an abuse of the system that's likely to occur in states that have adopted red flag laws.
You're absolutely right. And when we bring up red flag laws, I feel almost obligated to say the stupidity of these things is, if the person really is so dangerous they shouldn't have firearms, you're taking the firearms away, which is going to make them really mad, but you're leaving their car, you're leaving, all kinds of other, you're not taking away axes, you're not doing anything, and nothing else dangerous is being taken away. You're leaving them their freedom, you're just taking away one type of weapon. Bad.
Right, I think that's a great point. And in most instances, not only is there a possibility of making the situation worse, there are generally other mechanisms to achieve the same stated goal anyway. Most, or many states anyway, I believe, have like mental health commitment statutes or other mechanisms to avoid the possibility of someone who's so-called dangerous committing some horrible act. So I think red flag laws are sort of superfluous. They create a high possibility of that deprivation of rights without due process. So I think that the red flag laws are very flawed, to put it lightly.
Yeah, how about, let's take away their right to vote and then let them know about it. It's the same kind of thing. You need to be able to be represented. I don't want to say represent yourself, because anybody who represents themselves has a fool for a client, is the old saying. But you before a right is taken away, you need to be able to have your side represented. Always.
Right. Yeah. I think that there's this notion in the law, it's a legal maxim that's commonly known in the law, that a right delayed is a right denied. Mm-hmm. And it's a legal maxim that stems from many years ago. It's been referenced from times of the Magna Carta and in the Bible and even in American jurisprudence. But if somebody's rights are delayed, those rights are effectively denied. So I think that's what's partly so horrible about these red flag laws.
Well, and that's going to take us a little bit of a different turn, because as I was looking through news headlines just before we went to air, I seen a story that I commented to you about briefly. Mecklenburg County, North Carolina, Grassroots, North Carolina is taking them to court. That's Charlotte. Apparently, under North Carolina law, the sheriff has 45 days to issue a concealed carry permit. It's currently taking the sheriffs north of 7 months. They're 7 months behind, which means take 7 months, add 45 days. That's how long it's taking you to get your concealed carry permit. That is a right delayed, therefore a right denied.
Yep, that's exactly right. 7 months, 45 days is too long.
Yeah.
7 months is a disaster. So that came up. This is a little bit off topic, another tangent, but that came up recently in Indiana during the discussion of constitutional carry, when the Indiana House of Representatives passed a constitutional carry bill out of the House. They passed it overwhelmingly, but during the hearings involving constitutional carry, some law enforcement came in and said that, listen, what's the big deal? We are very good at processing license applications. People were very good at our average issuance time is only so many weeks. But what they didn't mention was that during the last year, it's taken months and months for them to process applications because they had been so overwhelmed with applications. So even if they had been efficient with the process in the past, you shouldn't have to wait for some bureaucrat to issue you a license to exercise a fundamental right.
Warsaw Patriots again comments, Chicago needs constitutional carry. I could not agree with you more. Man, your gang problems would plummet. Let me tell you what. I feel like I'm a paid spokesperson, and I'm not, for my home state, but the way it's handled in South Dakota, you are assumed, we have constitutional carry in South Dakota, you are assumed as an adult to be able to carry a firearm. If you want to have reciprocity with other states, you go to the sheriff's office, you pay your $10, and you are given a slip, and 7 days later one shows up in the mail. No big deal. For the enhanced permit, you have to take a course. It's a weekend. It's a few days on Saturday, a few hours on Saturday, a few hours on Sunday, and then you take that down to the sheriff's office, and it's a couple weeks, and you've got your permit in the mail. So,
I'm from Indiana, and I love Indiana. It's a relatively free state, but I'm going to sound like a salesman for South Dakota too. I thought Governor Noem there did an amazing job during the pandemic of trying to sell people on moving to South Dakota. Listen, we're not a state that's going to tell you what you can or can't do with your own life or with your children or with your business. We're not going to close you down. We're open for business, and we're not going to infringe on your individual liberty. So I thought that was a pretty effective message.
One of my favorite quotes from Governor Noem is, "We're going to assume you're a functional adult and can make your own decisions."
Yep. Wow. Until you prove otherwise, that's the way it should be.
Absolutely. I'm going to get four. We're coming up on the bottom of the hour. I'm going to get 4 comments in quick, and then we'll go ahead and shut it down. Warsaw Patriot says, "I will not just rely on the police. I am a human being and I have rights." Absolutely, bud.
Yep.
Barry Anderson says, "I live in Massachusetts. I could use as much 2A sympathy as I could get here." And John Lutine says, "The whole country needs constitutional carry." I'm guessing that's what he means by CC. But yeah, I'm honestly thinking, and I'm going to go out and I'm going to get my crystal ball out. And since the stroke, my crystal ball is a little cloudy. But I started my little tiny podcast almost 10 years ago, and when I very first started my podcast, I said, look, it took us from the 1920s to 2010 when I started. It was actually 2012. It took us from the 1920s to 2012 to get to where we are. We're not going back overnight, but I thought that in my lifetime, we could, through elections and more specifically, through court decisions, get to the point where we are basically a free nation again with regards to personal liberties and Second Amendment rights within my lifetime. I think we can get there. I still think we can get there. I think we can get to individual constitutional carry through the federal court system in my lifetime, especially if we keep the Supreme Court we have now.
Yeah, I'm optimistic like you, Paul, and you raise a good point. I mean, I think that we can gain back some freedoms, but I also think it's important to remember for people is that it's harder to gain back your freedoms than it is to keep them. So don't rest on your laurels. Fight to keep the freedoms you have, and hopefully it will protect those freedoms for future generations. So, of course, we can fight to get some freedoms back, but we need to focus on keeping the freedoms we have as well.
100%. I want to, last thing before we go, I mean, we do this almost every day, but I really want to hit the hammer again, on the nail again today. And everybody, please be contacting your senators. David Chipman's still out there. What am I trying to say? It's teetering right now as to whether it's going to be pulled. We need to be hitting all of our senators as hard as we can with phone calls, so that even places like in Illinois, Dick Durbin has shown some weakness. No matter where you're at, no matter what, if it's D or R behind your senator's name, they need to hear from you, and they need to hear from you today and tomorrow, so that your senator calls the Biden administration and says, look, pull this turkey. He's not going to get it. So.
Yep, agreed. We need to put as much pressure on our representatives as we can to make sure that Chipman doesn't get confirmed. And it's really easy to make that phone call to the Capitol switchboard and get in contact with your representative. So take just a minute or two out of your day and make those calls.
Absolutely. Well, Alex, thanks again for joining us, man. I really look forward to Fridays in our conversations.
Yeah, thanks again for having me, Paul. It was great.
All right, folks, we're going to go ahead and set this one aside. Come join us next week, Monday, for the Polite Society podcast at 6 p.m. Central Time. Then Tuesday through Friday, right here, same place, 5 p.m. Central Time, for the Daily Bullet. Thanks for watching, everybody.